Hi, my name's Ollie, and in this Politics Explained video, I'm going to go through everything you need to know about the nature and role of the US Supreme Court in Edexcel A-level politics. I'm going to start by looking at the parts of the specification this video covers and the key potential essay questions. From there, I'm going to give you an introduction to the Supreme Court, looking at how the role of the Supreme Court is set out in the Constitution and Acts of Congress. I'm then going to look at the independent nature of the Supreme Court, how it's kept independent, but also how this independence has been questioned, before finally looking at the power and the process of judicial review, including some examples of judicial review in practice and the debate over the Supreme Court's power of judicial review. The PDF you can see on your screen is part of an updated textbook on US politics that you can purchase on the Politics Explained website, where you can also find loads of essay plans and resources to help you in your politics A-level, as well as a place to sign up for tutoring if that's something you'd be interested in. Yeah, without further ado, let's get into it. So this is the first video on the channel in the US Supreme Court and Civil Rights, part of the Edexcel A-level politics specification, looking at the nature and role of the Supreme Court, so in the Constitution, the independent nature of the Supreme Court, and the judicial review process. In terms of questions this is going to be really useful for, you can get it, will definitely be useful in terms of questions comparing, so 12 markers comparing the US and UK Supreme Courts in terms of their powers, their origins and protections, their independence, etc. And it will also be really useful for a lot of these 30 markers on the Supreme Court. There's not going to be one 30 marker that's going to be just about this video, but it will kind of be really necessary to bring in particular, judicial review and its role in terms of independence into a lot of these questions about whether there's an imperial judiciary, whether it's a political or a judicial institution, and the extent of the power of the Supreme Court. So yeah, starting off, let's have a look at the introduction to the Supreme Court. Starting off with the Supreme Court in the Constitution. So the Constitution doesn't specify the exact powers and role of the Supreme Court, with much of its role later decided by laws passed by Congress and judicial precedent. But Article 3 of the Constitution does establish the court, set out its jurisdiction and how justices are selected. So it establishes the Supreme Court, and it says that the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. So this establishes the court as the highest body in the federal judiciary and gives it overall judicial power over the United States, in the same way that the president is given overall executive power in the United States. In terms of its jurisdiction, this is set out in Article 3, Section 2 of the Constitution, which sets out its jurisdiction as extending to all cases arising under the Constitution and laws of the United States. This includes it having appellate jurisdiction, in which the Supreme Court reviews cases that have already been decided in lower courts, and it's ultimately the ultimate court of appeal, so it can't be appealed beyond it. The Supreme Court also has original jurisdiction over certain types of cases, such as those involving ambassadors or where a state is party. So that's where it kind of goes to the Supreme Court immediately, rather than it being comes to the Supreme Court through appeals from lower courts. The Supreme Court's appellate jurisdiction sets up the fact that the Supreme Court addresses and decides on cases brought to it, rather than initiating legal action of its own. And this is important to the separation of powers and to the Supreme Court interpreting and applying the law, rather than trying to pursue its own agenda and make the law itself. In terms of how justices are appointed, Article 2, Section 2 of the Constitution outlines the appointment process for the Supreme Court, and it sets out that justices are nominated by the President and appointed with the advice and consent of the Senate. The Constitution also sets out that there is a Chief Justice who heads the court, and that Supreme Court justices have a lifetime tenure, as long as they don't commit impeachable offences or choose to resign or retire. And that kind of lifetime, the fact that the justices serve a lifetime, will come up a lot throughout the kind of Supreme Court topic, and is really important to understanding their power. In terms of the role of the Supreme Court that's been set out in Acts of Congress, Congress created the inferior courts below the Supreme Court through its legislative powers granted to it by Article 3 of the Constitution. And responding to these powers given to it in the Constitution, the first Congress passed the Judiciary Act in 1789, which set up the initial structure of the federal judiciary, including the creation of district courts and circuit courts, which are the two main types of courts that exist in the US today. District courts are the starting point for most federal cases. They're the trial courts where legal cases are first introduced and heard, and in these courts a wide range of legal issues are addressed, including both civil and criminal cases. Circuit courts, or courts of appeal, review decisions from district courts. They're slightly higher, They don't hold trials, but rather assess if the law was correctly applied in earlier cases. The next key thing is how Congress decided on the number of Supreme Court justices. As we kind of address, this isn't mentioned in the Constitution. So Congress set the number of Supreme Court justices at 9 in the Judiciary Act of 1869, seeking to avoid tie votes and prevent President Andrew Jackson from creating more justices. So Jackson was in conflict with both the judiciary and Congress and faced criticism for his attempts to reshape the court and its decisions through increasing the number of Supreme Court justices. Decades later, FDR proposed the Judicial Procedures Reform Bill in 1937, aiming to add more justice to the Supreme Court. This move, often referred to as court packing, was largely seen as an attempt to secure favourable rulings for his New Deal legislation, which has faced significant opposition from the court. And although FDR's plan was unsuccessful, it sparked a nationwide debate about judicial independence, the separation of powers, and the proper size and scope of the Supreme Court, underlining the enduring political and constitutional implications of the number of justices and the fact that it wasn't set out in the Constitution. So it would be constitutional for Congress to decide to increase the number of Supreme Court justices, but that's of course seen as deeply is very much a political issue and can be seen as kind of anti-democratic if it's done in order to secure certain rulings for one side of the political spectrum. In terms of the role of the Supreme Court, we're going to look at is kind of 5 key roles of the Supreme Court. So firstly, as we talked about, is the final court of appeal. So individuals dissatisfied with lower court rulings can appeal to the Supreme Court and they give the final resolution, and they're ultimately then the final arbiter of kind of interpreting the Constitution and the law in the United States. It interprets the Constitution to judicial review. So the Supreme Court employs judicial review to assess whether laws and executive actions are consistent with constitutional provisions. This authority allows the court to uphold the supremacy of the Constitution in legal matters and to interpret how the Constitution should be applied in practice. And we'll look at that in much more detail later in the video. It creates legal precedents, so decisions made by the Supreme Court establish legal precedents that lower courts are obligated to follow, thereby shaping the interpretation and application of law across the United States. It protects the rights, liberties, and principles set out in the Constitution, including through judicial review. So it kind of ensures that the key principles and individual rights included in the Constitution are preserved and that all branches of government adhere to them. And finally, it also checks the power of the executive and Congress. So there's a key check on the power of these two elected branches, reviewing and potentially invalidating laws passed by Congress or actions made by the president that exceed their constitutional limits. And so that's kind of a really key part of the system of checks and balances within the federal government. Okay, what we're going to have a quick look at now is the independent nature of the Supreme Court. So why the Supreme Court is independent. So the Founding Fathers intended the Supreme Court to be independent to ensure a robust system of checks and balances, a core principle underpinning the separation of powers of the US Constitution. By establishing an independent judiciary, they aim to create a neutral arbiter capable of making unbiased decisions based on the law and the Constitution, free from the political pressures and influences that might affect the legislative and executive branches. And this independence is crucial for upholding the rule of law, protecting rights, and preventing one branch from becoming too powerful. So the separation of powers ensures that each branch, the legislative, executive, and judicial, has distinct and separate functions, with the judiciary's role being to interpret the law and ensure that both the spirit and letter of the Constitution are faithfully adhered to by all branches of government. There's a number of measures that ensure that the Supreme Court is kept independent. As I kind of mentioned earlier in the video, lifetime appointments is really important. So they're appointed for lifetime during good behaviour, according to the Constitution. So they generally serve until they choose to retire or pass away, unless, of course, they're barred for impeachment or misconduct. And this allows them to be free from the pressure of elections or the need for reappointment. So they can make decisions exclusively based on the law, rather than based on political expediency or public opinion. The appointment process also ensures independence. So they're nominated by the president and must be confirmed by the Senate, and this ensures that justices are vetted by both the executive and legislative branches, promoting a non-partisan and qualified judiciary, whilst also preventing any sinful branch from having unchecked power over appointments. The Constitution stipulates that the salaries of judges shall not be diminished during their continuance in office, protecting them from economic manipulation or retaliation by the legislative branch. And this financial security supports judicial independence by ensuring that justice can't be coerced through salary adjustments. There's very limited possibility for impeachment or removal, so they can be removed only through impeachment by the House of Representatives and conviction by the Senate in the same way that the presidents can for treason, bribery, or other high crimes and misdemeanors. It's a really high threshold for removal, and this ensures that justices aren't subject to arbitrary dismissal, protecting them from the political whims and allowing them to decide cases impartially without fear of being removed. Only one Supreme Court justice has ever been impeached, and none have been removed from office. The one impeachment was of Associate Justice Samuel Chase in 1804, and he was impeached for alleged political bias in his judicial decisions and misconduct. But when the case went to the Senate for trial, he was acquitted and thus remained on the bench until his death. Crucially, another key way that the Supreme Court is independent is that they have control over case selection. So the Supreme Court has considerable control over its docket through the certiorari process, meaning that it can choose which cases to hear. This ability to select cases allows the court to manage its workload and focus on significant constitutional issues without external pressure to take up or avoid certain cases. Crucially, it must be recognised that it doesn't mean they could just decide to pursue any case they want to. It has to come up to them as they're the highest court of appeal, or it has to be something that they have specific kind of jurisdiction over, as I mentioned, so in relation to the states, for example. Crucially, the power of judicial review ensures the Supreme Court, it enables the Supreme Court to invalidate laws or actions that contravene the Constitution, so laws passed by Congress or actions by the executive, and this ensures that they can check other branches of government, reinforcing the court's role as an independent arbiter. And finally, the separation of personnel, as with separation of personnel between the presidency and the executive and Congress is really important. So individuals serving on the Supreme Court can't simultaneously hold positions in either the legislative or executive branches, ensuring that they're kind of exclusively dedicated to their judicial roles. In terms of how it can be questioned, however, the independence of the Supreme Court has come under scrutiny due to the increasingly politicised and partisan nature of the appointment process. As justices are nominated by the President and confirmed by the Senate, both of which are political entities, the selection of justices can reflect the prevailing ideological leanings of these branches, and selections can be made by politicians effectively to try and get certain decisions that are favourable to them made. For example, the Republicans are likely to nominate and select conservative justices because they're more likely to align with a lot of their key conservative principles and policy aims. For example, the overturning of Roe v. Wade was caused by the selection of a number of conservative justices by Trump. Especially in recent times with heightened political polarisation, the confirmation process has often become contentious, focusing significantly on the potential justices' perceived political and ideological stances. And this trend raises concerns that justices are being chosen for more their political compatibility with whoever's nominating them and confirming them, rather than the judicial qualifications, potentially leading to a bench that's seen as less as an impartial arbiter of the law and more an extension of the political battles of the day. The final thing we're going to have a quick look at then is judicial review. So, firstly, looking at the power and process of judicial review. So judicial review is the power of the US Supreme Court to interpret the Constitution and to judge whether laws passed by Congress and the actions of the executive are in line with the Constitution. If the Supreme Court judges that a law or action is unconstitutional, it can strike it down and reverse that law or action. The power of judicial review is really important as it allows the Supreme Court to decide on how the Constitution should be interpreted and applies. This means that it can update the Constitution in a way if it changes how it should be interpreted through interpretative amendments, which we looked at in the Constitution topic as well. It's also a key part of the system of checks and balances in the Constitution, as it allows the judiciary to prevent the executive and Congress from exceeding their powers or violating the principles of the Constitution. The Constitution doesn't explicitly set out that the Supreme Court has the power to interpret the Constitution. It was crucially established by judicial precedent in the case of Marbury versus Madison in 1803. And in this decision, Chief Justice John Marshall asserted that it's emphatically the province and duty of the judicial department to say what the law is. This case established the principle that the Supreme Court has a final say in interpreting the Constitution, and that it has the authority to invalidate laws that it finds to be unconstitutional. This was then reinforced 7 years later in Fletcher v. Peck, where it expanded the Supreme Court's jurisdiction to include state laws. So in this case, the Supreme Court, led by Marshall, ruled that a Georgia state law was unconstitutional. This was the first time the Supreme Court has invalidated a state law. So not only do they have judicial review in kind of ensuring that the Constitution is abided by in relation to federal laws and federal executive actions, they also have it in relation to state laws. And if we kind of quickly look now at the process of judicial review, so the first stage is case initiation. So a case is brought before the court when an individual or group challenges the constitutionality of a law or government action. This usually happens after the law enacted has been applied, affecting the plaintiff in some manner. Then the case often goes through lower courts before eventually being appealed and appealed again before it reaches the Supreme Court. So these lower courts may also exercise judicial review, but their decisions can be appealed, and ultimately it's the Supreme Court that makes the final decision on whether something is constitutional or not. The Supreme Court decides whether to hear the case through a process known as granting certiorari. I should really work out how to pronounce that. The court receives thousands of petitions annually, but selects only a small percentage for review, typically those involving significant constitutional questions or legal issues. Once the Supreme Court decides to hear a case, both sides submit written briefs arguing their positions. The court may also invite amicus curiae from friends of the court, from interested parties. Then oral arguments are held where attorneys for each side present the case and answer questions for the justices. After hearing the arguments, the judges meet in private to discuss and deliberate on the case. They examine legal and constitutional issues, interpret relevant statutes and constitutional provisions, and consider precedents. Each justice forms their opinion, and a majority is needed to decide the case. The majority opinion, explaining the court's decision and reasoning, is written by one of the justices in the majority. And there may also be concurring opinions, which agree with the majority but for different reasons, and dissenting opinions, when disagreeing with the majority. And these opinions are published and serve as precedent for future cases. So they have to really justify their rulings in terms of the Constitution and the law. The final decision of the court can result in the law or action being upheld, modified, or struck down. If declared unconstitutional, the law or action cannot be enforced, effectively removing it from practice, removing it from the statute book, and prompting legislative changes. In terms of judicial review in practice, the first kind of key example and really important recent example is Dobbs versus Jackson Women's Health Organization in 2022, which shows the power of judicial review, as the Supreme Court reinterpreted the Constitution to judge that there wasn't a constitutional right to an abortion. And this overturned the precedent set out by Roe v. Wade and Planned Parenthood versus Casey concerning abortion rights. The court reviewed the constitutionality of a Mississippi law that banned most abortions after 15 weeks. And in its decision, the court scrutinized the legal and constitutional basis for abortion rights, ultimately determining that Roe and Casey were incorrectly decided and the Constitution does not confer right to an abortion. So these previous cases had the Supreme Court argued that the Supreme Court does have a right to an abortion based on the 14th Amendment, particularly the idea of a right to privacy, and that the right to an abortion was part of the right to privacy. Whereas in Dobbs versus Jackson Women's Health Organization, the Supreme Court reinterpreted this and said that actually there wasn't a constitutional right to an abortion based on these grounds. You can also see it in Brown versus Board of Education in 1954, which is a high-profile example of judicial review where the Supreme Court used its power to end racial segregation in public schools. The court decided that separating children in public schools based on race was unconstitutional because it violated the Equal Protection Clause of the 14th Amendment. And this overturned the previous separate but equal standard from Plessy v. Ferguson, declaring that separate schools for black and white students were inherently unequal. Whereas the previous decision has said that yes, they were separate, but they were equal within the schools, therefore it wasn't against the 14th Amendment, in particular the Equal Protection Clause of the 14th Amendment. So this marked a significant step in the civil rights movement, leading to the desegregation of schools and greater emphasis on equality in education and other aspects of American society. And it shows the Supreme Court's role in using judicial review to kind of update the Constitution and correct social injustices, and interpreting the Constitution to reflect contemporary understandings of equality and rights. We're going to look at this in way more detail in the future videos on the channel on the Supreme Court. And the final thing we're going to have a look at in this video is the debate over the Supreme Court's power of judicial review. On the one hand, there's a lot of arguments for the Supreme Court's power of judicial review. It can be argued that it ensures that all laws and government actions align with the Constitution's principles and protections, and that this safeguards individual rights, liberties, and the principles of the Constitution by reviewing it and potentially invalidating laws that infringe upon constitutional protections. Judicial review acts as a critical check on the legislative and executive branches, preventing overreach and abuse of power. Also, it also allows the interpretation of the Constitution to evolve with societal changes, ensuring relevance and applicability in modern contexts, and that could potentially be seen in Brown v. Board of Education. On the other hand, there are a number of arguments that the Supreme Court's power of judicial review, or against the Supreme Court's power of judicial review. It can be argued that it isn't explicitly mentioned in the Constitution, instead it was effectively given to the Supreme Court by itself. It can be argued that it concentrates too much power in the hands of the judiciary and leads to judicial overreach, with courts imposing their interpretations rather than reflecting the will of the people or elected representatives. And this can be seen as undermining democracy, as unelected judges have significant power to overturn laws passed by democratically elected legislatures and signed by democratically elected presidents. And it can be argued that it relies heavily on the subjective interpretation of judges, which may be influenced by personal, philosophical, and political beliefs rather than objective legal principles. So yeah, that's everything in relation to the nature and role of the Supreme Court, as well as a kind of introduction to the Supreme Court in the US. I've got 5 more videos coming out on the channel in relation to the Supreme Court and civil rights topic. So make sure to have a look at all of them. And yeah, let me know in the comment section below if you've got any comments or questions, and I'll make sure to get back to them. And I'll see you in the next video.